Hi, Deborah. Thanks for joining us.
Hey. Hi, Shauna. Thanks for the opportunity to be here. And hi, Kai. Nice to see you. And really great presentation.
Yeah, totally. I don't see your presentation here
Oh,
anymore. So if you want to share your screen again, and I'll just read off your bio while you do that. Deb is a staff lawyer at West Coast Environmental Law for the Green Communities program. She works with communities in British Columbia to support stewardship of land and water for community and ecosystem health, including ecosystem-based measures to adapt to climate change. The work involves understanding the legacy of colonial development, including regulatory gaps and failures in existing Canadian Crown law, and supporting new approaches to regulation and management at landscape scales in ways that uphold Indigenous laws and authority and constitutionally protected title and rights. And so here is your presentation, and I will just leave the screen and leave it over to you.
Great. Thanks, Shauna. Thanks so much for the opportunity to be here today virtually with everyone on the call. I'm actually here at home in my basement, and apologies in advance because my neighbor is doing some work next door, and it might be in the background a little bit sometimes. And my home is here on the north shore of Burrard Inlet on the shared and unceded and ancestral territories of the Squamish, Tsleil-Waututh, and Musqueam peoples. And I'm always very grateful to be here in this beautiful place as an uninvited guest, but working and living here with my family. So I guess what you were hoping to have me speak about was ecological governance from a legal perspective, and I'll try to do that. Although I also wanted to just kind of set up the context of where we are, because I think, as you can see from Kai's very inspiring presentation, there's a lot of content to add to, particularly to the way Crown laws are operating in the places where we are, and also many opportunities and responsibilities to go forward now in a good way that recognizes, fully recognizes and upholds Indigenous jurisdiction and Indigenous living laws and legal traditions on the territories where we all live. And particularly, we're talking today about the Islands Trust area. And I put ecological governance ... question mark, because I think it's even like a question, like we have to fill that in. And I'm actually happy that I got to go after Kai, because I think it was important to start the conversation thinking about what we want to see, rather than saying what are the kind of, in some cases, clunky tools that we have, particularly in our colonial Crown law governance framework. And how do we best use them? I really think it's much more effective to start with thinking about what we want to accomplish and how we want to change things. And I guess that aligns with where I work, West Coast Environmental Law. We are a not-for-profit environmental organization. We're mostly lawyers with some comms and development and admin staff. We've been around for more than 40 years, and we're really interested in laws that safeguard the environment, and also laws that and working with law in a way that upholds our commitments that we now have this formal expression of them in the United Nations Declaration on the Rights of Indigenous Peoples. So also interested in solutions that kind of bridge between these two overlapping legal landscapes, but recognizing that they do coexist, and they both are very much alive here for us. So I work on the Green Communities program, and we've done quite a bit of work in past years thinking about what it means to live in urban areas and try to reconnect with the nature that we are a part of, and recognize those relationships, and especially what does that mean in a changing climate where definitely some of the issues are really coming to the forefront. So in terms of the Islands Trust Act, I want to just give a kind of a quick overview now, which is pretty dry compared to some of the exciting and compelling ideas that Kai has put forward, but just to have us have this in mind, this set of rules that we work with, and what some of the opportunities might be. So in the Islands Trust area, we have a governance framework that, of course, is established by statute by the Islands Trust Act. And so it's a provincial statute, so it reflects responsibilities and powers that can be delegated by the province under our constitution and the division of powers. So that's where it comes from. And it has this very interesting feature that's quite distinct from other provincial legislation that gives local governments power, and that, of course, you're all aware, is the Islands Trust Policy Object. And I won't read out the whole thing, but really the key pieces are this: preserve and protect the trust area and its unique amenities and what that might mean, but a really affirmative mandate to do this work. And what's not there, however, in this definition is anything when they're talking about cooperating, doesn't mention Indigenous nations. And of course, whether or not it says in this, in this object, in this piece of legislation, in this small provision, whether or not there should be cooperation with Indigenous nations. Nonetheless, Indigenous nations are here, and their rights and title are protected in Crown law in the Constitution, but also inherent jurisdiction exists independently of recognition in Crown laws and still apply. So the policy statement itself, it's a Section 15, subsection 1 of the Act requires a policy statement that essentially articulates how the trust object is going to be carried out, and it also says that it can be different for different parts of the trust area. The policy statement is adopted by the Trust Council and then approved provincially by the Minister of Municipal Affairs. And of course, as you know, there's a process right now underway to review the policy statement, which was adopted some years ago. And then the effect of the policy statement going forward within the trust area is that any bylaws submitted to the Executive Committee and the Trust Council must then be consistent with the policy statement. So just a little recap on the governance structure that's established within the Islands Trust Act. You have the local trust committees on the different islands, and that's two elected representatives. Then you have the Trust Council, which is made up of those all of those municipal trustees. They create then from amongst themselves an executive committee, and then there's also the Trust Conservancy Board, which is a separate organization. But then within this structure, how it works with respect to the impact of the policy object and the trust policy statement, all the local trust committees, they send all their bylaws to the Executive Committee for ultimate approval, and they must be consistent with the policy object and the Islands Trust policy statement. But in the case of municipalities, the municipality of Bowen Island, they only have to send their official community plan to the Executive Council for review of its consistency. But for greater certainty, there is a provision that was added to the Islands Trust Act that says that municipalities as well must consider the policy object when they're adopting any bylaw or issuing a permit or license. So just to be clear that their authority still includes what's in the policy object. And so the way that this operates then, the kind of special preserve and protect provisions of the Islands Trust Act is to, I guess you could say, condition the powers that local governments have within the Islands Trust. So it's not exactly necessarily seen as an extra power to what local governments have elsewhere in BC, but it's a kind of saying like this is the way that you have to exercise those powers. And so the local trust committees have the same powers to regulate the development and use of land that regional districts would have under the Local Government Act. except they have to be used in this way. And then an interesting thing that I came across when I was looking at the Islands Trust Act recently that I hadn't been aware of before was that there is a specific provision in the Islands Trust Act that says that Cabinet can, by regulation, make more powers available to local trust committees that currently exist in the Community Charter and the Local Government Act, other than those that already apply. And so just for clarity around that, the Community Charter is what applies to municipalities generally in the province, and the Local Government Act applies more generally to regional districts. So in addition, so I'm not making that so clear, but the municipalities also have the planning powers and the land use regulation powers under the Local Government Act, but then the Community Charter gives them some kind of broader powers in some cases. For example, an issue that's come up around tree protection. The Community Charter gives local governments the ability to regulate tree protection on private property within their boundaries, not just on public property, public municipal property, that is. So that's a kind of interesting piece that Cabinet could just add that. And in fact, in the Islands Trust regulation, there are already some specific powers that under the Local Government Act and the Community Charter, aside from the planning powers, that most of them relate to kind of administrative things that are already assigned to governments within the local, within the Islands Trust. So, but getting to the heart of things here, and not wanting to spend too much time, because I think it will be more interesting to have some discussion around this, and also to hear from Joni and her perspective on this from the Saanich Council point of view. But what is the content then that we could put into what we have here, and also how does it go forward in a way that fully recognizes Indigenous jurisdiction as well, which will be an essential part of any solution that's arrived at. So, what is ecological governance? Well, we don't really have a definition for it. But trying to think of some of the elements of what it could entail. First, obviously, legally, we have the policy object and the preserve and protect trust area mandate, which is distinct, and I think we could see would align with protecting ecosystems and really recognizing human nature relationships as well. In the Local Government Act, in the planning section, when there's an official community plan, there is a requirement to include greenhouse gas reduction targets. So that's another piece, a little piece of the climate change management from a mitigation point of view. It doesn't say what the limits are and targets are supposed to, or what the targets are supposed to be, rather, but it does require them. We have the Heritage Conservation Act, which is the provincial legislation that aims to protect archaeological cultural sites. It's not perhaps not the perfect piece of legislation, but again, it is something that is there and kind of can be used in helping to protect the really deep history of the region. And then we have of course, very importantly, and it's last but it's not least, meant more like in a foundation way, we have the Declaration on the Rights of Indigenous Peoples Act, which essentially aims to bring into force the United Nations Declaration on the Rights of Indigenous Peoples in BC, and all laws going forward are meant to be consistent with the United Nations Declaration according to this act. And we haven't really seen this in action yet, but it's there. So that is helpful to have that in Crown law as well. What's missing on the Crown side in terms of thinking about ecological governance? Well, there's provincial authority under the Constitution that hasn't been delegated within the the trust area related to the management of forest activities, forestry regulation. There are others, and then also on the federal side, federal powers related to fisheries navigation and a number of other things that they're very relevant for the trust area. So there's always going to be this bundle of things from a Crown point of view that aren't part of the picture. And then what's needed to bring these legal requirements to life? Well, first of all, we really need to have a good understanding of what the ecosystems that we're depending on, what they need in order to thrive, and that includes what they need in order to thrive in a changing climate that we are bringing about through our human actions. And then, and Kai touched on this as well, we need some agreement that we're going to manage and limit human activities appropriately. And I think there are a lot of ways that we could do this through the existing powers under the Islands Trust Act, for example, but we would need a collective political and social will to do so. And then underlying everything, we really need collaboration and respectful coexistence. And so we need relationship building, and we need to all work together and come up with a way that we're gonna live together well for the long term.